something has shifted in American gun law, and most gun owners have no idea it happened. Over the past 90 days, a series of court decisions, Supreme Court signals, and legal developments have quietly changed the rules of the game for assault weapon bans across this entire country. And when you connect all the dots, the D.C. ruling, the Third Circuit case, the Supreme Court signals, and the Bruen framework, you start to see a picture that looks very different from what the anti-gun media is telling you. Are assault weapon bans finally over? Not yet. But for the first time in decades, the legal foundation under those bans is cracking, in multiple courts, simultaneously, from multiple directions. And I am going to walk you through every single development with authenticated sources, real case names, real quotes, and real data. Before we get into the specific cases, you need to understand the legal standard that is now being used to judge every single gun law in America. 10 states and the District of Columbia currently ban assault weapons in some form, while 14 states and the District of Columbia restrict the possession of large-capacity magazines. All of these laws have been challenged in court by gun rights groups. Every single one of those challenges is being fought under the framework established by the Supreme Court's landmark 2022 ruling in New York State Rifle and Pistol Association versus Bruen. That ruling changed everything. In its 2022 Bruen decision, the Supreme Court went further than ever before by saying the Second Amendment gives all Americans the right to bear commonly used arms in public. It also said that to pass constitutional scrutiny, a law limiting the right to bear arms had to be consistent with the nation's historical tradition of firearm regulation. That standard, consistent with historical tradition, is now devastating assault weapon bans. Here is why. There were no AR-15s in 1791. There were no 30-round magazines. So states trying to defend these bans have to find historical analogs from the founding era that justify banning the most popular rifle in America. And they are running out of arguments. Similar popularity among the law-abiding applies to semi-automatic rifles like the AR-15, so any judge faithfully applying the Supreme Court's precedents must come to the same conclusion about the unconstitutionality of banning them. Unless and until the Supreme Court intervenes on the issue, however, these dishonest and disingenuous legislative battles will continue. Now let's get to the most important recent development, and it happened just weeks ago. In early March 2026, the District of Columbia Court of Appeals, the highest court for D.C., ruled that the city's ban on magazines holding more than 10 rounds is facially unconstitutional under the Second Amendment. Writing for a 2-1 majority, Judge Joshua Deal, himself a Trump appointee, concluded that magazines holding more than 10 rounds are arms in common and ubiquitous use for lawful purposes and therefore squarely protected under the Constitution. The actual words in that ruling are critical. Judge Dale wrote, 11+ magazines are unquestionably arms. They are in not only common but ubiquitous use for lawful purposes, and there is no history or tradition of blanket bans on arms in such common use, so that the district's magazine capacity ban violates the Second Amendment. The court noted that magazines capable of holding more than 10 rounds are commonly owned across the United States, and therefore fall within the protections of the Second Amendment. This new decision creates a legal conflict between courts over whether bans on magazines violate the Second Amendment, a disagreement between courts often called a circuit split, and is one of the key factors the Supreme Court considers when deciding whether to hear a case. And the ripple effects were immediate. In a memo filed March 11th with the 7th Circuit Court of Appeals in Chicago, lawyers for the gun industry asked a 3-judge panel hearing the Illinois challenge to consider the D.C. ruling. Illinois lawyers challenged the ban on large-capacity magazines, and the D.C. decision is now being cited as authority for why the Illinois ban should fall too. New Jersey rushed a filing to the Third Circuit on March 18th, urging the court to ignore the Benson ruling, writing, "This court should reject the non-binding outlier ruling in Benson v. United States." The state also complained that the D.C. decision remains subject to en banc review and conflicts with every federal circuit to have considered assault weapons. New Jersey is not filing panic letters because it feels confident. It is filing panic letters because it sees the legal ground shifting under its feet. While D.C. made the recent headlines, the case that legal experts are watching most closely is playing out in the Third Circuit, and its outcome could be the first domino that brings down assault weapon bans across multiple states. A challenge to New Jersey's AR-15 ban was heard by a 3-judge panel over the summer, and then, before the panel rendered a decision, the court, without being asked, decided to hear the case again en banc. The Third Circuit case might be the first final appellate decision that does strike down an assault weapons ban, said Andrew Willinger, executive director of the Duke Center for Firearms Law. I would not be surprised. That is because the court's balance has now tipped toward judges appointed by Republicans. With the confirmation of Donald Trump's recent judicial appointee Emil Bove, the en banc Third Circuit is now a 7-6 Republican-appointed court. At least one other Republican appointee, Senior Judge D. Brooks Smith, appears to have elected to sit on the en banc panel, giving it a potential 8-6 conservative tilt. That means gun rights advocates could stand to lose one or even more conservative judges on the question, and still potentially end up with the first-ever federal circuit split over the constitutionality of assault weapon bans. The oral arguments in the case were revealing. On October 15, 2025, the Third Circuit en banc heard arguments on New Jersey's prohibition on numerous semi-automatic firearms and magazines holding over 10 rounds. The challengers argued that the banned firearms are bearable arms in the meaning of the text, and that the Supreme Court in Heller decided that arms in common use may not be banned under the history and tradition test. That is where the Benson decision becomes so damaging to the anti-gun cause. The D.C. Court of Appeals did not describe these magazines as rare or fringe. It described them as ubiquitous in our country, making up about half of the magazines in the hands of citizens, and coming standard with the most popular firearms sold in America today. That is devastating language for any state trying to argue that millions of peaceable Americans can be disarmed from owning standard rifle magazines because politicians have decided they are too dangerous. The Supreme Court has not yet directly taken up the AR-15 question, but multiple justices have made their views unmistakably clear in written statements. Justice Thomas asserted that the challengers in the Maryland assault weapons case should have prevailed. He stated that tens of millions of Americans own AR-15s, and the overwhelming majority of them do so for lawful purposes, including self-defense. He called the constitutionality of the ban a question of critical importance that warranted immediate review, arguing that further development in the lower courts would be of little value. Justice Kavanaugh called into question the Fourth Circuit's decision upholding Maryland's assault weapons ban. He also emphasized the value of continued lower court percolation, citing 5 assault weapon cases currently on appeal in different circuits, and suggested that the court should address the issue in the next term or two. That statement was made in June 2025. We are now in that next term. The cases are piling up, and the legal landscape is shifting in ways that even the most optimistic gun rights advocates did not predict just 1 year ago. 11 states currently have assault weapon bans in place, with various other states like Virginia, New Mexico, and Minnesota actively moving them through legislatures this session. Rhode Island is even trying to retroactively strip grandfathering protections from gun owners who were originally allowed to keep their legally purchased firearms, potentially making formerly lawful owners into felons. So are assault weapon bans finally over? Here is the honest answer as of April 2026. They are not over yet, but the legal architecture that has protected them for decades is fracturing in 3 places simultaneously. The D.C. court just struck down a major gun restriction using the common use standard, directly threatening magazine bans in California, Illinois, New York, and New Jersey. The Third Circuit, now majority Republican appointed, is about to issue the first appellate ruling on New Jersey's AR-15 ban, with a very realistic chance of striking it down. And the Supreme Court has 2 justices who have stated publicly in writing that AR-15 bans cannot survive constitutional scrutiny, with more signaling they will take up the question soon. If the Supreme Court eventually takes a magazine ban case, the Benson ruling will be part of the foundation for a ruling that could sweep away 10-round limits nationwide. That would not only restore the rights of millions of gun owners, but would also send a clear message that the Second Amendment protects the arms and accessories people actually use, not the watered-down versions politicians wish Americans would accept. The rules have changed, the courts are moving, and by the end of this Supreme Court term, sometime in late June 2026, the legal map for assault weapon bans in America could look very different than anything we have seen in the past 3 decades. Subscribe to this channel. Share this with every gun owner you know. This story is moving fast, and we are going to cover every single development as it happens.